Thank you. And I call Stephen Kerr.
Well, I think the bill's a mess. I think it has struggled its way through the different stages of this Parliament, and I think today's Stage 3 amendments were evidence of that. I found it particularly dismaying that the government caved in to the Scottish Greens. I'm sure for the very simple fact that they realise that without the Scottish Greens this bill will not become law. But they sold their shirts, frankly, and I'm not entirely sure what for, to be honest, because the bill is totally unnecessary. There's no need for this bill. And I think that Miles Briggs was right. I think we've ended up in a situation where no one's very happy about what the bill contains. And I predict, in support of my colleague, that this bill will be the subject of litigation. This will be in the courts, and I don't think there's any doubt about that. And I'm not sure that I'm at all convinced that the Cabinet Secretary is at all convinced about the necessity of the bill either. What we had until this bill arrived was some clarity around the legal position on religious observance. Parents had the right of withdrawal. Schools implemented that parental wish. The lines of responsibility were well understood. This bill replaces that clarity with a statutory mess that formalises disagreement, inserts the school into the space between a parent and child on matters of conscience. And teachers and school leaders are now required to assess maturity, interpret capacity, potentially refuse a parental request. They're being drawn into adjudicating questions that go into belief and upbringing, and this is not a simplification, this is a complication, and it places teachers, I think, in an invidious situation. They're educators. They're not arbiters of conscience within families. Absent safeguarding concerns, they should not... Yes, of course.
Cabinet Secretary.
I thank Mr Kerr for giving way. The features around conflict were actually discussed at length in the evidence sessions led by the Equalities Committee, and it is the case at the current time that conflict exists. Does the member accept that conflict exists under the current arrangements, and does he not also accept that the way to ameliorate that conflict is for the government to work with mandatory stakeholders and provide statutory guidance to help support those conversations as and when they arise?
Stephen Kerr.
I don't doubt there's conflict that exists currently, but it exists within a very clear framework of law. This is not a clear framework of law. Well, I think we might actually have to disagree on that. The Cabinet Secretary is correct. Of course, children must be respected and they must be heard. But we also recognise a foundational truth on this side, that children are children. Capacity develops, responsibility develops. That's precisely why parental responsibility exists in law. Parents carry duties because children do not yet carry full legal responsibility. That settlement is not outdated. It reflects human reality. And what concerns me more broadly is the direction of travel reflected in this legislation, because there are voices in our politics who are increasingly uneasy with the idea that the family is the primary unit of moral and social formation. There's an instinct that the state should stand above the family as the final arbiter of disputes, even where no harm is alleged. I reject that instinct. The family is the foundational institution of our society. Families come in all forms, but they share a common function. They are the place where children are loved, nurtured, guided and formed. The state can support that. It cannot replicate it, and it should not casually displace it. What we have seen in recent years are attempts to extend the reach of the state into areas once clearly understood as parental responsibility. The Supreme Court has reminded this Parliament that constitutional boundaries exist. And I think I'm over time, so I will conclude by saying Scotland has been long served well by strong families and strong schools, each respecting the proper boundary of the other. I do not believe the necessity case has been made for unsettling that balance, and for those reasons, I and we on this side will not support the bill in its final form.